I'm going to need you guys to sign that, please. Good morning. Are you Kaylin Billups?
Yes, ma'am.
And this is cause number 19-32315. Ms. Phillips was previously in court on probation for a deferred probation for aggravated assault with a deadly weapon. And there's a motion to revoke. We were previously here, and she entered pleas of true to counts 1, 2, 4, and 5 in that motion. And I've received the updated report. Have you both had an opportunity to review that report?
Yes, sir.
Yes, sir, we have, and after speaking with probation and Mr. Kimler, I think we have an agreement
Okay.
to follow the
recommendation.
recommendation of safety.
That's correct, Your Honor.
Okay, so
We need to resolve the misdemeanor, which hopefully I can do that this morning.
all right, Ms. Phillips, in cause 19-32315, I'm going to find that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. However, probation has made a recommendation, and it sounds like everyone is willing to work with you to give you an opportunity to be successful. And so I'm going to go along with that recommendation and continue you on probation. Order that as a condition of your probation, you enter and successfully complete the SAFE-P program, the special needs SAFE-P. That will give you the treatments you need, hopefully, for everything going on, mental health, drug abuse, whatever it is, so that when you get out, you can be successful and you'll have the tools to be successful. It's important that you do everything you're supposed to, make the best out of that treatment. When you get out, you will have aftercare that will also be a condition of your probation. So it's important that you do all of that as well. Do you understand?
Yes, sir.
If not, and you violate again, I can assure you, if you're back in here on another motion, things will not be this easy. Do you understand?
I understand.
Okay. This was not an agreement. You do have some limited rights to appeal. Mr. Kimler will hand that to you. I wish you the best of luck, ma'am. You can go back with the bailiff, and thank you, ma'am, for being here. Mr. Kimler?
Yes, I'm sorry.
Good morning, sir. Are you Jorge Del Fiero? And Mr. Del Fiero, in cause number 25, DCCR 0892, you're charged with third-degree felony offense of assault family violence by impeding breath or circulation from January 31st of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler.
Yeah.
This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, including a no contact with the complaining witness. Do you understand?
Yes.
You have every right to reject that offer and go to trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, sir.
And do you want to reject that offer and have your case set for trial? All right, we'll get that done. And Ms. French, is there any reason to believe that that offer would change in any way?
It's gone now.
Okay.
Just to be clear, Your Honor, it's a condition of his bond. There is a no contact with the victim. Is that correct?
There should be.
Yeah. Contact. All right.
Yeah, so it's important that if it isn't already, I'm sure it is, a condition of your bond is that you have absolutely no contact or communication with Amelia Adams.
Yes, ma'am.
That obviously means in-person contact, but it also means sending messages through other people or social media or anything like that.
To be sure of child loss, so there has to be some internet communication or visitation.
So there are apps you can use, like the Family Wizard, where you don't have to have actual contact, but you communicate through an app that saves everything. It kind of protects both of you, so that all communication is saved on that app. It shows it's only about what's going on with the child, pick up, drop off, school stuff, whatever it is. My suggestion would be that you use that, unless you have some third party, a parent or grandparent or somebody to help. But it's a nice thing to use anyway, really just to protect yourself, so that you are, and it's kind of handy, you know everything that's going on with the child. If you have something, you can put it on that. If she has something that's going on, she can put it on that, so you can both see what's happening with your child, doctor's appointments, things like that.
So to be clear, our communication via the app is not a violation of the bond condition.
Correct, as long as it is only about the child. Now, if you're on that app and you send something that is not about the child, it's saved and we're going to know about it. So that's the best way, and the way that I would definitely approve for you to have contact only with regard to the child.
Yes, ma'am.
Okay?
You understand?
I do want to make sure you understand that after today, I will not accept this plea agreement. It sounds like it's off the table. So if you change your mind later and want to enter a plea of guilty, it would either be open to the court or to some other agreement. You understand?
Yes.
Okay, we'll see you back at trial then. Stay in touch with Mr. Kimbler.
You got this good? Good.
Good morning. Are you Peyton Woodruff?
Yes, ma'am.
And Mr. Kimbler, will your client waive the formal reading of the indictment?
She will. Here. Why don't you make the meeting for it? Just keep an eye. Keep an eye.
Let's see. Let me get to it. All right. All right, Ms. Woodruff, in cause number 26, DCCR 0034, you're charged with the state jail felony offense of possession of a controlled substance, and that's from March 2nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimbler?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 4-year deferred probation. There would not be a fine. You would be required to follow all of the rules and conditions of probation. This would run concurrently. It looks like you're already on probation for cause numbers 24 DCCR 1710 and 25 DCCR 0426. And I'm guessing that's just because this was
It preceded
those because of.
Yes, ma'am.
Possible.
Is that your understanding of your agreement?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Woodruff is not competent?
Understand.
And because she's already on probation and this is a state jail and everything.
Waiting. Yes, I do.
All right. So Ms. Woodruff, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to follow all of the rules and conditions of probation. And if you do that, again, this is an excellent opportunity. You do not have the felony conviction on your record. Obviously, if you violate any condition of probation, you'll be back in here on this case and the others. And in this case, facing a sentence in prison of up to 2 years. Do you understand?
Yes, ma'am.
And if you're successful at the end, the case will be dismissed, also just like the others. All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, man.
Thanks, Judge.
Thank y'all.
Yes, ma'am.
Good morning. Are you Morris Williams?
Good morning, yes.
And this is 26 DCCR 0359. Mr. Williams is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Announcement is the state and I have been in communication. There's some shared concerns that we asked for a little time to address if we could get another setting. Yes, ma'am.
Any issues? No. All right, I'll just do a normal reset and to give you guys some time to visit. Mr. Williams, stay in touch with Mr. Jeffries so y'all can visit before the next court date, and we'll see if we can get an announcement then. All right?
Thank you, Your Honor.
Y'all are free to go.